Good day, and welcome to the Foley's Access to Capital Preparing Your Organization for Affiliation or Sales web conference call. Today's conference is being recorded. At this time, I would like to turn the conference over to Ms. Adria Warren. Please go ahead, ma'am.
Thank you, operator, and welcome everyone. I'm Adria Warren. I'm a senior counsel with Foley and Lardner's healthcare industry team out of our Boston office. And we appreciate your dialing in today, and I am confident that it will be an informative session and well worth your while. We have a great panel lined up today. This is the fifth in Foley and Lardner's ongoing series on access to capital. The series is available on our webpage, and if you've dialed in before and you've enjoyed the sessions, we hope that you will consider joining us this fall as we're launching a three-city series of in-person conferences in Boston, Chicago, and San Francisco. And the conferences are going to focus on trends in hospital mergers and acquisitions and stages of the deal. So stay tuned. Before we begin, I'd like to go over a few housekeeping tips. If you can flip the screen. There's a number here at the top of your screen if you need technology assistance, 888-569-3848, and dial *0 for audio assistance. We are going to have, following the panel's presentations, we're going to have live Q&A, either through the computer or the phone, and you can enter your questions at any time on the right-hand side of your screen. And we will leave time to address them, so we encourage questions. We also encourage you to maximize your presentation by clicking on the full screen button located above the slides, and you are welcome to print the slides as well. There's a copy of slides button on the right of your screen. We are going to apply for 1.5 hours of CLE credit. New York and New Jersey attendees have to fill out an attorney affirmation form, and we're going to announce 2 course codes during the course of the web conference. And so listen for those codes, and then you can also, if you don't have a form, you can contact zrahim@foley.com. And her email address is at the bottom there, but it's zrahim@foley.com. So I think that takes care of the housekeeping matters. The prior access to capital sessions explored in depth the economic and regulatory pressures and the ever-changing landscape that's putting strain on hospitals and healthcare systems, and also the availability and efficacy of some of the options that are available to hospitals looking to position themselves for success in the future. And as we look back at 2012, even in the light of the uncertainties leading up to Supreme Court's upholding of the Affordable Care Act and the presidential election, healthcare M&A volume was strong, and transactions by healthcare facilities and providers, such as hospitals, continued its year-over-year increase. And I think the general consensus is that these trends are likely to continue for the next few years as providers look to simplify and consolidate their systems. With that in mind, today we're going to shift inward. We brought together a wonderful panel with deep industry experience and diverse perspectives to lead us in a discussion about how your organization might be proactive and position itself for a potential transaction. So during the session, the panel will explore ways to approach identifying and establishing your strategic priorities and understanding some of the priorities for both if you are looking to acquire or affiliate and to be acquired and be the entity that would be giving up control in a transaction, and also the potential resulting implications for compliance and governance and finance and operations. I've asked each panelist to speak for about 10 to 15 minutes. Following the remarks, as I said, we like to encourage discussion and have an interactive presentation. So to introduce the speakers, Richard Reiner is the Executive Vice President of Adventist Health System and the President Chief Executive Officer of Adventist Multi-State Division. In his role, he provides leadership to 20 Adventist hospitals, and he also chairs the board of Centura Health, which is a joint operating company for 4 Adventist facilities in the Denver area, and he's the key liaison for other joint ventures. Richard's presentation today will give us insights into what a potential acquirer might value and a potential target might prepare for. Trey Crabb is a managing director with Ziegler's Healthcare Practice, and he's focused on mergers and acquisitions and strategic services. He has over 20 years of healthcare experience providing both not-for-profit and for-profit healthcare organizations in strategic advisory transactions as well as debt and equity capital raises. Prior to joining Ziegler, Trey founded Health Strategy Partners out of Nashville, and he also worked with Merrill Lynch and Bank of America, providing merger, acquisition, affiliation, joint venture, capital raising services to healthcare organizations nationwide. Trey is going to walk us through the decision process and the due diligence that typically goes into a transaction from a business standpoint, offering some very practical tips. And then following Trey, we will have Roger Strode, who's one of my esteemed partners with Foley and Lardner. And Roger is probably one of the reasons Foley's been named the #1 health law firm in the U.S. for 2 years running by U.S. News and World Report. Roger's practice focuses on healthcare business transactions, including mergers, acquisitions, corporate restructurings, and joint ventures, general corporate matters, healthcare regulation, and he has great experience representing institutional healthcare providers at hospitals, health systems, integrated delivery systems. He's participated in lead counsel in numerous healthcare and corporate transactions. And Roger is going to give an overview of compelling legal issues of which your board and management should be aware as they embark on a strategic transaction adventure. So without further ado, I'd like to turn over the program to Rich. Rich?
Well, good afternoon. This is Rich Reiner. I'm going to share a few slides about who Adventist Health System is, but I'll also suggest or make you aware that for about a 12-year period between the middle 90s and up and through the late 2000s, I had the good fortune of participating in about 5 affiliations, mergers, acquisitions, when standalone community hospitals or a group of small community hospitals decided to join Adventist Health System. So I'll put a little perspective at the end of my slides. I'm going to go quickly through the slides just to give the attendees a quick idea as to who Adventist Health System is, and then I'll transition with my colleagues into the other part of the program. We're a faith-based organization, and that's evidenced by our mission and our values. We do have the good fortune of being the largest non-Catholic faith-based healthcare system in the U.S. with 44 hospitals in 10 states. The revenue, the bond rating, capital spend are all listed there on the slide. I won't read those to you. We are in the 10 states. The stars represent acute care. We also have, I'll go back, we also have 16 long-term nursing home, subacute facilities, and a significant number of home health agencies. If you look at Florida and you see all of the cities listed there, that's where the majority of the merger and acquisition activities took place that I referenced just a few minutes ago. Financial overview for the year end ending December 2012. Those are listed there, and some of the key metrics that we measure. Of course, we measure many, many other things, but those are just some that we share with our board to give a picture of what's happening. We've obviously seen a flattening of admissions in most of our markets, as I think most of healthcare has experienced in terms of inpatient admissions. ERs continue to grow as well as outpatient revenue. Our payer mix is probably pretty similar. This is an all-in company payer mix. It will vary by market, of course, from as high as 70% Medicare in some markets to as low as 20% Medicare in some markets. That obviously does change the financial strength of the various hospitals that represent those. We've seen a flattening, like the industry has, of rate and volume over the past couple of years as we are transitioning out of the recession and into more Medicaid, more self-pay, and less commercial and more Medicare. And that probably is pretty typical of most national health systems if they put these kinds of slides up, as they would experience what we have experienced. Our income statement for the year was robust, given some EHR settlements, and the wage settlement with CMS allowed us to post a strong bottom line for 2012. We're blessed to run a pretty stable EBITDA margin, which allows us to participate in some affiliation discussions and market growth opportunities. And we've used a very conservative investment philosophy, and if you compare that to a 50-50 blend, we really are no worse off having a conservative investment philosophy over the last 12 years. Days cash on hand continue to be stable and strong as we reduce debt. And as we talk about mergers and acquisitions, one of the things we have in our vision statement is that anything we do from a purchase or a merger standpoint must be accretive to our balance sheet within the near term. And near term is defined as probably 24 to 36 months. And another metric we measure is cash to long-term debt. We have a very stable ratings history. Those are referenced there, and they go back as far as 2000. And we have improved our balance sheet significantly. At the same time, we've done a number of mergers and acquisitions and joint ventures. As referenced, we have, besides wholly owned hospitals, a number of joint ventures. If we're don't have a strong market position in a certain market, we try to partner up with somebody who does, to give us the scale in the market that's important from a lot of different perspectives. I'm not going to go into any of these in any detail. I am going to speak a little bit to some of our experience in mergers and acquisitions, because I think I have a few minutes left on my time. Most of the time, the 5 hospitals, community, not-for-profit hospitals that have chosen to join Adventist Health System here in the state of Florida have done it for probably 3 or 4 reasons, and they would be as follows. They want to affiliate with a strong market brand, and in this market, Florida Hospital, who has been in this market meaning Orlando, sorry, I should have defined that. Our corporate office and many of our core assets are in Florida. You saw that from the map that I put up. It's very strong brand recognition, and most of the time, the facilities in the Central Florida market that have been acquired and been a part of us usually take on the name Florida Hospital. So there's a naming convention with Florida Hospital, and then usually a geographic after that, such as Florida Hospital Flagler, Florida Hospital Altamont Springs, etc. So joining for brand recognition, joining for capital capacity and access to cheaper, more available capital. Most of the time, the organizations that have joined us have joined because they had big capital projects they wanted to do, many times replacement hospitals, and weren't able to, because of their own modest balance sheet, weren't able to put together an adequate enough financing and financial pro forma that would make the project feasible in the bond market. Or they became tapped out from a growth perspective and wanted to grow in other markets that were adjacent to their core facilities and didn't have the balance sheet to accomplish that either. And probably the third is they were lacking in an IT strategy. That was true even back when IT became what most hospitals were working on in the late 90s, early 2000s. We still had a more robust and well-deployed IT strategy that the hospitals saw benefit in joining. There were some other key strategies, and those will come up as my colleagues present some of their slides. And so with that, I think I will stop and let others present and then participate in the Q&A.
Okay, great. Thank you, Rich. And Trey, do you want to turn to also giving us some insights into what's driving these changes and what we might do and what we might think about as we embark on our own transaction?
Absolutely. Adria, thanks for including me in this webinar. It's nice to be doing this with Foley, with whom we've worked on a number of transactions, and also Adventist Health System that's been a 30-year client of our firm. So thanks again for having us with you. we spend a lot of time with our clients helping them think about remaining independent, perhaps through pursuing joint ventures, partnerships, etc., because many of our clients that may have operated in a given market for 100 years want to remain there and keep their identity. At some point, though, boards of trustees and executive management make the decision to pursue a sale, and I wanted to speak to some of those considerations leading to such a decision. If you look at this slide, page 23, there's some recent research that was put out by Moody's that focused on a few relevant points I thought were good to include. If you think about all the pressures that are in the market that might drive someone to a decision to affiliate or sell themselves, these are some of the more important ones. And Rich mentioned this in particular when it comes to some of the groups that have come into his system, the need to find capital to modernize their plant and IT systems. It's one of the things that gets pushed off and off at some hospitals, and at some point reach the conclusion that they really need to reinvest in their physical plant, and many times the only way to do it is to find a partner. Greater limitations on access to capital are happening today in today's market. The issue here really is the widened spreads on the lower rated credits that we follow. It's harder to get, it's more expensive and harder to get access to the market for some of those lower rated credits. Increased reimbursement pressures amongst all payers. That's true for Medicare reimbursement, certainly Medicaid, if you think about state budget issues that we hear about, it seems like every day, and commercial insurers that are keying off of some of those price decreases that are coming from Medicare. Large unfunded pension liabilities. Even with the movement from defined benefit plans to defined contribution plans in many cases, low interest rates have made it more difficult to continue to keep those plans funded. And then benefits of tax exemption. You hear, it seems like in the press every week, that someone, not-for-profit, is having to justify their tax exemption, and that is probably not going to go away. And then finally, the benefits of economies of scale, including bargaining power that you would get with suppliers, payers, and labor. So to the extent that you've decided to enter into a transaction, what are some of the goals that you might have? Some of the things to think about in advance are the services that we're currently providing. Is it important to us to make sure that those are maintained? If we partner with another organization, do we want to be sure that they reinvest in the hospital and in our community? How do we feel about everyone that's working at our hospital? Do we want to be sure that their jobs are protected? Do we want to be sure that our partner can help us turn around our operations and minimize our ongoing losses? What about our executive team? Some partners that come in won't hire your executive team, and they'll bring in people from the outside. Is it important to us to make sure that our executive team is protected in a transaction? Or should we just try and create a foundation? Some not-for-profits look to sell themselves to the highest bidder and successfully create a very large foundation with the proceeds that are obtained from those types of transactions. So with those preliminary comments, what kind of transaction or affiliation will best serve us? Is it a sale where we have cash proceeds coming in perhaps with a for-profit company? Is it a joint venture or a partnership? And some of those are cashless, which can increase your access to capital, improve your credit, help you gain market share, et cetera, but don't necessarily create the opportunity to create a foundation. And then finally, governance is something that is always at the forefront of our mind. What happens in a sale or affiliation with another party? Who runs our hospital? What are the rights and responsibilities that we have at the place now that we're going to affiliate with another bigger party, let's say? How long does it take on slide 25 to do these kinds of transactions? Once you've made the decision to do something, it can take up to 12 months. I'd say 6 to 12, but it really depends on the organization. The thing I mentioned at the beginning is when you make the decision. You may have gone through a multi-year process to decide this is something that we should do. So many times conversations that we have with clients lasts for 3 years or more, trying to make the decision and going through the process of discernment to get to the point where they want to enter into a transaction. And then that time frame can be extended in terms of the deal itself, depending on the structure of the transaction and the state where the deal is. Some state attorneys general have the ability to review transactions, and many times that review can last for 30 to 90 days and require lots of follow-up. So do you need an advisor for this kind of work, someone like us or legal advice? The hard thing to justify and to put your finger on is what is it that we don't know in a deal. You could get through a transaction and successfully complete it, and 5 years from now only realize that you missed something in the documentation or on the business side that would have been nice to have someone to help you up front think about. Many times hospitals engage someone to help at the very end of the deal, and sometimes it's too late. Your negotiating position has been lost. And again, finally here, what feels like the most obvious candidate might not be once you start getting down into the details. For example, who is it that's going to pay for capital expenditures once my hospital is now part of another? Is it me? Is it the acquiring entity? And how do we calculate how much capital we are able to spend? That is controversial in many cases because everyone's understanding of how much capital is going to be spent changes after the deal closes, and it's nice to have those kinds of things negotiated before you enter into the deal. So once you've decided to sell, preparing for this is key, and I'm going to spend the rest of my speaking time talking about that preparation. So preparation can help keep things on track and make sure the deal doesn't get delayed or sidetracked. If issues arise during the buyer's due diligence, and quite frankly, your own reverse due diligence, if you choose to investigate your potential partners before entering into a transaction with them, you can respond to issues quickly. And if those issues are discovered early, we like to ensure that, especially on the sell side, that the partner that has won the opportunity to enter into a transaction with you, that their pricing doesn't change or their terms don't change, because we want to avoid last-minute surprises of that nature. And finally, closing proceeds very quickly. So what preparation should be undertaken in this? We're going to get into some detail on that now. First, deals with referral sources. This is something that we work very closely with our legal colleagues on, but when issues come up of this nature, they can quickly turn into a business issue, which is where I tend to get the most concerned. Referral sources, as you know, are highly regulated, and there's financial issues that can arise when arrangements of this type go awry. So you need to look closely at anti-kickback statutes and the Stark Law to make sure you're in compliance. One example of an event that occurred that did become a business issue in a transaction is a financial relationship that the Detroit Medical Center was engaged in that was settled back in 2010 that enabled a transaction to go through with Vanguard down in Nashville, which is where I live. And that's an example in the grand scheme of things, not material to Detroit Medical Center, but the issue itself was very material and can become a business issue in transactions. So steps to take now with respect to referral sources are to identify those referral sources that you have, determine whether or not financial relationships exist, determine whether that relationship is compliant and is it arm's length. And then specifically you want to look at physician employment agreements, leases, medical director agreements, and supply agreements with physicians. If you find something that's non-compliant, as you're preparing for a transaction like this, you want to try to work on that right away and document it well. Going to billing and coding matters, you need to be able to demonstrate that issues identified in old audits that you've done have been addressed and remediated, so that you've done the work to prove that out. Consider doing a new audit to demonstrate that you're in compliance. Even a minor issue could look significant to a buyer and can turn into a go, no-go decision issue for a buyer or partner, because they want to be sure that the hospital that they might bring in an affiliation is of the same mind that they are. So this could be a very big deal, even if it's not material from a financial point of view. And then be sure your revenue cycle management systems are up to date. The question I always ask at the very beginning of a transaction is, are your net collections equal to your net patient revenue? If they're not, then your allowances are probably off for better or worse. You want to be sure that those are in balance. And if it's out of balance the wrong way, then you could be running into a cash crunch that is going to creep up on you. As it relates to licenses, permits, and accreditations, all your permits should be up to date and unrestricted. You should be sure that any suspensions or investigations by regulators have been closed out. Skipping down to the last bullet here, showing improved policies or successful follow-ups can help to evidence that you've addressed those issues. And then finally on licenses, the third bullet there, be aware in advance whether a change of ownership will affect any of your licenses or permits. And there's some wiggle room here depending on how you structure the deal. If it's a merger or a stock deal versus a purchase or an asset transaction, you may be able to have a slightly easier road getting licenses transferred than otherwise might be the case. So sometimes change of control is easier with a merger or a stock transaction. Going to bond and debt issues. Many times these types of deals are driven by bond covenant defaults or being over-levered. Let's say you took on a project that's really stressing the financial condition of your hospital and you need to find a partner, or you've gone several quarters and you're in default with some angry bondholders. So sometimes this forces hospitals into a partnership. So the question that you have to ask yourself is, given what we're worth today, will we be able to satisfy our current debt and other obligations? And if the answer is no, or we're not sure, then you could be operating in the zone of insolvency. So this starts to get to a really distressed situation, and you may end up needing to restructure or otherwise settle your debts in or outside of bankruptcy court. And that could be with or without a partner. So definitely engage with the review of your bond and debt issues with your counsel to make sure that you understand your rights and responsibilities before entering into a transaction, and your bond banker can help you there as well. So commercial insurance relationships, payer contracts. Hospitals looking at buy-side deals look at Medicare and Medicaid contracts first. But at the end of the day, commercial insurers pay for a significant portion of health care in the U.S., so understanding these contractual relationships is important. The key issue here is understanding the waiver and discounting of patient co-payments and deductibles. How do your commercial insurers treat your out-of-network policies and apply to patients who visit out-of-network providers? What happens in case of noncompliance here? Sellers should consider a preemptive change here to be sure that your policies are in good shape and in compliance before entering into a transaction. and be sure that your documentation is in good shape here as well. One special thing I'll mention as far as a business point is concerned, depending on the type of contracts you have, when buyers come in and look at transactions with your hospital, they many times are discounting from a valuation standpoint your out-of-network reimbursement that you received. And so, I think the days of being very profitable based on having out-of-network business are largely over at this point. And so if your hospital is in the situation where you have a lot of out-of-network business, if you're not already, hospitals are definitely moving away from that kind of reimbursement because it's likely going to become very scarce if it hasn't already. Let's see. Compliance issues. You're going to get some inquiries on compliance here. Does your plan address all of your risk areas? How recently has the compliance plan been updated? Do you have a compliance officer and a privacy officer that can take calls from any employee at any time on an anonymous basis when something is seen? Do you complete training on compliance on a regular basis? Do your board minutes reflect compliance discussion? And again, the point below is what I've said already. Do you make an attempt to solicit compliance issues from your colleagues? A little bit more on contracts. The core contracts that were asked for in due diligence include those related to vendors, suppliers, customers, payers, lessors, and lenders. I'll say one thing about payer contracts here again. If you're considering a transaction with an in-market competitor, I'm sure everyone has seen all of the recent press as it relates to Phoebe Putney in Georgia, as it relates to Rockford in Illinois. The Federal Trade Commission is very focused on in-market competition. If you enter into a transaction with one of your in-market competitors, even if you don't think that you'll trip the kind of the rules and regulations around market concentration, you're going to have to hire a consultant to be in the middle of that payer contract review until the deal is largely approved to avoid any conflict of interest there. Anyway, going through the rest of this here, you have to think about in a transaction contract provisions that can cause challenges, including the assignment of those contracts, change of control, which we've already talked about, liability issues, restrictive covenants, including non-competes and non-solicits, and termination clauses. Now to patient privacy issues. You need to be sure that you're in compliance here with all rules and regulations, including the HIPAA Act and HITECH Act, and be sure that your documentation is in good shape here. It's an area of focus from buyers looking at hospital transactions. Other issues that I thought of off the top of my head, when you think about contracts and you've decided to enter into a transaction, be sure that you refrain as much as you can from taking on new multi-year contracts. One of the ones that I see over and over again is a decision 6 months ago to enter into a 7-year deal with an information technology provider to provide for hardware and software for revenue cycle management or some portion of revenue cycle management, and there are multi-million-dollar payments that are going to be required every year on that from now on. And many times the partner that you're looking to do a transaction with uses a different system than the one that you've just entered into a contract with and would have preferred that you had not entered into that contract. It's just better to be as nimble as you can be and put off multi-year purchases as much as possible, both on IT and other issues. Also, for the time being, it's best to avoid non-maintenance construction and physical plant improvement commitments. I'm not saying stop the normal course of business maintenance that you're doing to your facility, but entering to a new patient tower construction project, for example, could scare away potential partners if that's not what they would have chosen to do themselves. So I'm advising you to use some caution on those kinds of new projects once you've decided to do something as well. Work closely with your board of trustees and the board-appointed committee to establish priorities in this deal. Create a small working group of deal team members that you can share everything with and everybody's under the tent. And then think about confidentiality and sunshine issues, particularly if you are a county or state-owned facility, because much of what you discuss has to be made public. Looking at slide 36, you know, a little bit more detail on the time frame. We mentioned before already that up to 12 months is the typical time frame. I won't spend too much time on this here, but I'll leave it for you to take a look. And you know, certain of these things can be skinnied up as far as time frame is concerned. Many times our clients want us to get started right away, and so we can get a confidential information memorandum written and out to the market very quickly. But pushing too hard on partners' due diligence is not something that we advise, because you really need to be able to give them time to be sure that they're the right fit for you, and that you can consider whether or not they're the right fit as well. But up to 12 months. So let's talk a little bit about a transaction that turned out well for Marquette General, and it's one that's been in the news quite a bit from a Nashville-based company down here, LifePoint, who has a joint venture with the Duke University called the DLP JV. Marquette General Hospital in the Upper Peninsula of Michigan, a bit of financial distress up there, 275-bed hospital. The goals of the transaction that they had were to shore up their debt and pension liabilities, similar to what we talked about, update their aging plans, which we've talked about as well, to work on quality issues in some of their service lines, and to stop patient out migration to some neighboring markets. They identified more than 25 potential partners on that deal, received 10 proposals, and so Duke LifePoint was the chosen partner. And it really caused a bit of a stir in the market to think why a North Carolina-based academic medical center would consider going to a place so far afield. And this works out with the quality piece here, because Duke is providing telemedicine and other protocol suggestions and help to Marquette General in a market where it's really unusual to have that kind of a medical center doing that. And so they're very happy with that relationship, I hear, from both sides. Plus, they were able to get a very substantial commitment on capital improvements and take care of their debt. So I think I have spoken all of my time. Adria, I'll turn it back over to you.
Thank you, Trey. And my colleague Roger is going to speak about some of the compelling legal issues that you might want to be aware of. One thought that's in my mind is that you've covered a lot of ground, Trey, and one thought that I know I've seen in transactions, and I am sure we all have, is that sometimes these issues kind of pop out of the woodwork once the deal gets going. And Roger, I'm wondering if in your remarks you can kind of address what might be expected. You know, hopefully we're laying a good foundation as we go forward, but what happens if we don't? Thanks.
Thanks, Adria. Good morning, everybody. I guess in some places it's not morning. Where I am, it's still morning. But we really appreciate, we from Foley really appreciate all of you that have dialed in, and we appreciate all of you who've dialed into the other access to capital webinars, and we hope that you've gotten that you've gotten some really good information out of these deals and out of these webinars. What I guess I'd like to talk about in connection with preparing for some sort of an affiliation. And I don't really know that it matters whether you're on sort of the majority player side, the buyer side, the seller side, the minority player side. As you know, these transactions can take a lot of different forms. And what I really want to focus on are just kind of three major areas that when I think about my clients getting ready for a transaction, these are kind of the three big areas that we hit up front, whether we're on the acquirer or majority side or on the seller or minority side in a transaction. And the first of which is really the board process and how the board prepares the organization for an affiliation. The other thing we look at are then, what are the upcoming material governmental approvals and material third-party consents that we're going to need to get so that we can plan for the transaction and time the transaction appropriately. And then third, and Trey's covered some of this, the diligence and the compliance issues that could unravel a deal later on. With respect to board process, a lot of boards, boards are like any sorts of organizations, and they sometimes mirror their organizations. Boards can be very, very sophisticated and tend to be sometimes in very large organizations, and in other organizations can tend not to be very sophisticated. Smaller community hospitals where you have a lot of volunteer board members, some of whom may have been on the board for a very, very long time, but really aren't involved in the business of healthcare on a day-to-day basis. They may be community leaders, but they're now living in this world of healthcare payment reform, Obamacare, whatever you want to call it, but the business of healthcare has become substantially more complicated than it was 10 years ago, 5 years ago, 10 years ago, 20 years ago. And all of a sudden, many of these men and women may be kind of out of their depth when it comes to considering an affiliation. From everything from, should we do an affiliation? Do we need to affiliate? Do we need to sell? Should we buy? To how do we do it? How do we structure it? What kind of deal terms do we need to look at? What does the future hold for us? So because of that, what we often recommend and what we see good organizations do is make sure that their board is very informed through the process and that the board understands what their duties are and what their obligations are with respect to the organization. We do see, and I'll talk about some practical tips in a few minutes, we do see many organizations putting together smaller board committees or smaller, really advisory committees to the board that what they do is they evaluate affiliation alternatives. They then are often involved in engaging advisors, whether they be lawyers, whether they be investment bankers, strategic financial advisors, and then they're often involved throughout the affiliation process in vetting the transaction documents and going through. And this is the group that tends to then keep the board advised. We oftentimes see these groups are sometimes will be the executive committee of the board, and sometimes they'll be a subset of the executive committee of the board. Board chair, maybe a couple of trusted board members, this oftentimes then the CEO, and then professional advisors. Just a couple of things to keep in mind, that board members are fiduciaries, and they have certain duties to the entity whenever they're considering a transaction. And the two big duties we think about all the time are the duty of care and the duty of loyalty. And the duty of care is something that's really your initial and your primary duty. And that is that board members are supposed to be informed. They're supposed to act in good faith. They're supposed to exercise this sort of ordinary and prudent care. And so then the question is, well, what does that mean? When I'm a board member and I'm preparing for this kind of affiliation process, what am I supposed to do? And oftentimes the way we advise boards is that the ultimate decision to sell, to buy, to affiliate, not to affiliate, the decision that you reach ultimately, while important, sometimes is not as important as the process that you undertake. And that concept is really embodied in what the lawyers call the business judgment rule. And what the business judgment rule says is that board members should be sufficiently informed and in good faith and with the honest belief, and do things in good faith and with the honest belief that what they're doing is in the best interest of the organization. The business judgment rule really focuses on process. So in practical terms, what does that mean? Well, it means things like if you're trying to consider whether or not your organization should affiliate, you need to have data. You need to have good financial data. You need to have good market data. You need to understand what's going on in your market. And if you don't understand what's going on in your market, you need to make sure that you as a board hire the appropriate people, that your management is informing you, and that management is helping you make decisions along with professional advisors. Again, investment bankers, strategic financial advisors, lawyers. It's not so much that every board member needs to be an expert in healthcare and healthcare transactions, but what they need to do is make sure that if they don't understand something, if they don't get it, that they get the right advice so that they do get it. Another board duty that board members have is the duty of loyalty. And what the duty of loyalty says is that board members are supposed to exercise their board powers in good faith and in the best interests of the healthcare system, the hospital, and its mission, and not in his or her own best interests. And what does that really mean? Two big things is you have a duty of confidentiality. That is, you need to keep your deliberations confidential, so that I oftentimes advise, even though board members generally have signed covenants of confidentiality, or it's generally understood that board deliberations are confidential and that as fiduciaries they're bound to keep the deliberations confidential. I advise oftentimes that board members go ahead and sign new covenants, because what it does is it's a psychological thing. It reinforces to your board members, hey, the stuff we're talking about, it's pretty important stuff, and we got to be careful not to go out into the community, not to discuss it with physicians, not to discuss it with payers, not to discuss it with local employers. That's not really the appropriate thing to do. You can really harm an organization's ability to effectively do a deal if you're out talking about the deal. This is something that's especially important for physicians who sit on boards. And the physicians need to very carefully consider this, because physicians are oftentimes impacted. I mean, not oftentimes, they always are impacted by these transactions. And there's going to be a desire of the physicians to talk with their colleagues, or their colleagues are going to come to them and say, you're on the board, we know you're on the board, we want to talk about what's going on. This is something that you need to really carefully reinforce with your physicians on these boards. The other thing is that if you as a board member have business interests or business relationships with this organization, those need to be fully disclosed, and to the extent, and this goes regardless of whether or not you're involved in a transaction, but it's particularly important in a transaction, that you need to very carefully disclose to everyone your business relationships with the organization and determine whether or not the transaction will impact them. If the transaction impacts them, the board then needs to make a decision as to whether or not you as a board member should recuse yourself. Again, sort of practical tips. I think it's always important to focus on an informed affiliation process. As we said, use a subgroup. A hospital CEO that I worked with one time said that he likes his board committees to feed the bigger board the elephant a spoonful at a time. And what I mean by that is you need to have, these transactions sometimes can take anywhere from 6 months to 18 months to, God forbid, 2 years, depending upon how you're doing things and going through the process. I believe you need to have regular check-ins with your board, because what you don't want to do is spring a transaction on an entire board after you have literally worked on it for months and then dump it on the board in a 1 or 2 hour board meeting and say, we need you to approve this. I've seen that happen. It's generally a disaster. So feeding information to the board, in pieces and building every time you have a discussion with that board. Remember what we talked about last time? Remember we told you we were going to do this over the next 6 weeks? Well, here's what we've done. The next time you check in, you go back to the first 2 things you talked about and you add a 3rd thing. So by the time you get done the last puzzle piece is the approval that you need for the transaction. The other thing is that this informed affiliation process, it focuses on what the board doesn't know and doesn't understand and should understand. I think it's always important to focus on the mission of the hospital or the health system and its service to the community, you as a board member. Again, being skeptical, asking questions. If you don't have answers to things, if you don't understand things, make sure you do understand things. And you do that by hiring subject matter experts, legal counsel, financial advisors, etc. And again, ferreting out conflicts early in the process is very, very helpful. So, step one in this is making sure that your board is informed and making sure that you have a solid board process when you go through the affiliation process. The next thing to think about are material governmental consents and other third-party consents. In many transactions, you should understand that depending upon how the transaction is structured, but clearly in many states, if a not-for-profit organization is going to sell its assets to a for-profit organization, you likely will implicate what are called the Cypre doctrines and the charitable trust doctrines. And essentially, what those doctrines say is that in many cases, the Attorney General of the state that you are in may have the right to review and or approve the transaction. Some of these Cypre doctrines and charitable trust doctrines are simply common law, and they're just course of dealing. Others are statutory. Others are done through rule process or protocols. Whatever state you're in, you need to look at the transaction ahead of time and say, listen, we're going to put together, a joint operating company between two not-for-profit hospitals, or we're going to sell a not-for-profit hospital to a for-profit, or we're going to sell a not-for-profit hospital to another not-for-profit hospital. You have to determine whether or not that transaction is going to trigger any sort of state AG or other state approval process. Again, it may require approval in some states. Pennsylvania and Ohio are good examples. There's a fairly robust approval process in those states. And it may require court approval. For example, in Pennsylvania, after you actually get sort of the AG sign-off and you've gone through that process, you then have to go to the local court of equity, what's called the orphans court, and get it approved there. What I generally recommend is if you're in a state in which you need to go through this process, you generally need to let the state AG's office or the charitable trust division of the state AG's office know early that you're going to be coming to them and giving them a heads up. They don't like to be embarrassed. Sometimes these things can be very, very political, and you need to make sure that they understand what's going to happen. And again, even feeding them the elephant a spoonful at a time. What are these AGs going to be interested in? Generally, just as a general rule, they're interested in who the buyer, who the affiliation partner is, and are they going to preserve the mission of the hospital that's being acquired or sold. Again, they're very, very interested in the process. This gets back to that business judgment rule. This ties back into the board process and the organization's process for figuring out who the affiliation partner is going to be. Oftentimes that process is more important than the actual decision. If it's going to be sold, if there's actually going to be a sale here as opposed to an affiliation, they're going to want to understand that the price to be received is fair for the hospital, and they're going to look at things like appraisals, fairness opinions. Again, what process did you go through? Did you go through an auction process? And then finally, they're going to want to understand how the net transaction proceeds are going to be used. In many cases, again, if there's a sale, if there's going to be a sale, they'll expect that a foundation will be established to hold the proceeds, and that foundation will then utilize those proceeds for healthcare needs for the local community. Excuse me. As Trey alluded to earlier, another set of laws that you have to think about are the antitrust laws. The antitrust laws may very well be implicated here, and you have to plan for the antitrust. You have to plan potentially for antitrust scrutiny depending upon, one, the size of the transaction as well as the market concentration. Are you in a hospital market where you're going to go from 4 hospitals to 3 hospitals when the affiliation is over? Are you going to go from 3 to 2? Or are you going to go from 2 to 1? The FTC and the Department of Justice have been very, very active over the last couple of years in a number of markets, Rockford, OSF, ProMedica in St. Luke's in Toledo, Phoebe Putney down in Albany, Georgia, and there are a number of others. In fact, they started even looking at the concentration of physicians between hospitals that merge or hospitals that come together that own physician groups. They're going to look at the impact of the transaction both on the hospital side as well as on the physician side. So what you need to do in that instance is the first thing you need to do is understand, are we going to have a market concentration problem? And if we're going to have a market concentration problem, are there good arguments to be made that this transaction is pro-competitive? If you're going to do that, you're going to need to know these answers early. And again, probably hiring antitrust counsel and likely having that antitrust counsel hire an economist may be important to your transaction. I generally advise that you do have the economist hired through the lawyer to protect privilege on whatever information that you get. The other thing you have to then determine is, am I going to have to file Hart-Scott-Rodino? Hart-Scott-Rodino is a filing that's made with the FTC and the Department of Justice, and it's made both by both parties to the transaction. And essentially what you have to do is file some level of deal documentation, and then there are all kinds of questions that you have to answer to the FTC about market, services, etc. And then you have to file a bunch of other documents, and we'll talk about those documents in a minute. They're called 4C documents. You have to file documents with the government, and then you wait. And the government will either terminate your waiting period early and say you can go ahead and merge, or they will just let the 30-day waiting period expire, at which time you can go ahead and complete your transaction. Or they will make what are called second requests, which means we want to look closer at your transaction and we don't want you to complete the transaction until we've given you a termination of this transaction. One of the sets of documents that you have to file, and this is where it goes to the planning process, are called 4C documents. 4C documents are essentially any documents that you have internally that address market shares, pricing, etc., this transaction. And so if you've prepared things internally and you know that you are looking at a transaction that may have some competitive impact, and you also know you're looking at a transaction in which you are going to have to file Hart-Scott-Rodino and notify the FTC and the DOJ that this transaction is going to happen, you're going to want to be very careful about the documents that you prepare internally. Emails, all kinds of things that aren't privileged can become 4C documents, and unfortunately some of those documents can be very troubling and very problematic for a transaction if they say things in them that would indicate that the transaction otherwise might be anti-competitive. So that's part of your planning process, is to be very, very careful about those documents. Other material consents you have to think about is in states that have certificate of need. In many states, for example, in the state of Illinois, if two hospital systems were to come together, you'd have to go to the Illinois Health Facilities Planning Board and ask their permission to affiliate those two hospitals depending upon your structure. Oftentimes you may be able to get what's called a certificate of exemption, but it's still a process you have to go through. So early on, if you are in a CON state, you need to figure out what you need to do and what the best course of action and the best affiliation structure is if you are in a CON state. That process sometimes can take you 4, 5, 6 months, depending upon whether or not it's challenged. You need to get into a rhythm. You need to get into the board approval cycle, which means you've got to plan for when you make your application so that you get on the docket, so that you can get to the next board meeting, et cetera, et cetera, et cetera. So those are things you need to think about. And often in those same states, depending upon the affiliation structure, you may have an impact on licensure. There may be change of control. You may trip over change of control statutes in the states you're in and require that you go get licensure approval for a change of licensure. Other big consents you need to look at, and Trey hit on many of these, are bondholder consents, other material lenders, capital lessors, significant physician groups with which you have contracts. You need to think about your material contracts and determine whether or not your transaction structure is going to trip either change of control, assignability provisions, et cetera, and plan for how you're going to get those third-party approvals to get the transaction done. That's all part of the approval process. finally, the last area that I want to talk about and just spend a minute or two is to talk about diligence and compliance. Depending upon which side of the transaction you're on, you're either going to do diligence on yourself or you're going to do diligence on the other party. And in many cases, both parties do diligence on each other, especially in these not-for-profit affiliations where you're coming together either as a 50-50 or a 60-40, whatever that might be. You need to understand that sophisticated affiliation partners are going to be concerned about liability around coding, billing, Stark law violations, anti-kickback risks. From my standpoint as a lawyer, where we see most of the issues tends to be, the biggest chunk of the issues tend to be around Stark law issues. Trey, spoke of referral issues. Stark law issues can be a very big deal. The Detroit Medical Center transaction is one example, but when Condell came together with Advocate and was acquired by Advocate, Advocate refused to close the transaction after they had done diligence until Condell went through a self-disclosure process with the CMS over problematic physician contracts that led to, I think the number is something around $30 million worth of repayments, penalties, etc., back to the CMS for Stark law violations. What you have to remember about diligence is that once you cut a deal, if you're going to sell, the price is never going to go up. It's only going to go down if the party to the other side finds problems. It may unravel your affiliation if the party to the other side on the other side finds problems. You need to do diligence on yourself. And what I normally say is if you're thinking about an affiliation, you should work with counsel and work with your bankers or work with your advisors and get together diligence lists and begin to populate a diligence room, generally, some sort of either physical room or populate an online room where you can review documents, because you'll be your clients and you will be very, very surprised at some of the things that you find through that process. So doing diligence on yourself sometimes is as important as doing diligence on others. So really with that, Adria, I'd like to turn it back over to you guys.
Yeah, thank you. Thank you very much, Roger, and thank you all the speakers. That's very interesting. You gave us a lot of things to think about. And I guess I'd like to go back to Rich, if I may, and from an industry and business standpoint, if I am looking at all this information and all the things that I've heard I should be doing now, how do I really think about prioritizing what the issues are? And that may be for coming at it from the perspective of the target and what my priorities might be given the transaction, or, or as an acquirer and having gone through these transactions yourselves, what sort of red flags would you be really looking for and, in due diligence and selecting a partner?
Well, I'll speak to it as an acquirer. We do a lot of due diligence. We want to understand all of the physician contracts, make sure there's no regulatory problems with any of those. We have learned the hard way. We want to have a very detailed physical plant assessment. Many times organizations will starve their physical plant because of lack of capital, and we recognize going in that we're going to have some expenditures to bring them basically up to new code or to new acceptable operating parameters. We just want to understand what that number is. So we do actually, as the gentleman suggested, do assemble a full due diligence room where we ask the organization that we're about to acquire to bring all of their documents, leases, contracts, accreditation, anything that has the potential to affect the ongoing operation from a financial or operational perspective, so that we can look at it. And of course, any letter of intent is subject to the acquirer being able to do all those due diligence activities. Of course, depending on the size of the transaction, you have to do the HSR filing and so on. If I'm the organization being acquired, or basically allowing myself to be merged into a larger organization, then I would do some due diligence as well in terms of our what's our past experience, Many times we have facilitated a meeting of community board members who do shift in our structure from being totally fiduciary to being only partially fiduciary, and many of the big financial decisions and approvals rest with the corporate board. We will facilitate a meeting of community board members from an organization that has already been through the process with us, and we believe they would say has been successful with those that are considering it, and they have a sort of a no-holds-barred discussion without any of us in the room. Many times also we encourage somebody that's being acquired to have a consultant. There's probably a number of community board members who are reluctant to give up control or organization to a larger organization. Sometimes a consultant, if they haven't had one, is useful to provide that third-party independence in terms of assessment of options and to give community board members the comfort that this is the right thing long-term for the institution. I'll stop there and see if there are further follow-up questions.
Well, and as you go through, and partly drawing off of what I had asked Roger before, as you go through this process, have there been instances, or is there something that you might consider a deal killer, or how flexible would you be in working through an issue with your target if something came out of the woodwork while you were undergoing your review?
Well, we early on probably can make a determination as to whether a discussion and a potential acquisition / merger would be beneficial to us financially and beneficial to us as the acquirer from a market perspective. And depending on the culture of the organization and whether, from our perspective, staffing and expense levels are such that we'd have to do pretty draconian reductions in the short term in order to not have it dilutive to our balance sheet. We early on, about 4 years ago, made an assessment that it would take about 6 years to get where we needed to go, and it would be such a culture change to the organization that while we thought it would be a very helpful acquisition long term, we didn't think 6 years of pain was worth it. So in that case, it was a financial and a cultural decision that caused us not to pursue it.
Okay, thank you. Very interesting. And I'd like to follow up on that. But first, let me give the code for CLE credit if there's any lawyers on the line from New York or New Jersey. So grab your pens. The first code is M as in Mary, W as in Walter, V as in Victor, Z as in zebra, and the number 0. And so MWVZ0, and then I'll read one more. We have a question coming in from a listener, and the question is, when would the price discussions really start? I mean, when do you start, kind of going into timeline? When do you start pricing discussions and really kind of thinking about the substantive deal terms? And I might, Roger, do you want to take a start with this?
Sure. I mean, in my estimation, I mean, this can go one of several ways. If you are talking about a sale, and you're talking about a sale whether to a non-for-profit or for-profit, oftentimes it'll be led by a banking group, like somebody like Trey or his group, and they'll oftentimes go out with either a book or requests for information and asking people whether or not they're interested in a particular transaction, and they'll put out a book. And with that book, there'll be a bunch of financial information in there. And oftentimes, they'll either ask for responses back, which is sort of, expressions of interest. And in many cases, some of the expressions of interest will have price in them. And you'll begin the process of kind of whittling down the potential acquirers, the potential suitors and buyers. And at that point, that's when you start getting into the, please give us what you think the value of this organization is. And oftentimes at that point, the suitors will have already had, they'll have had P&Ls, they'll have had balance sheets, and they'll have had some sense of what the organization's worth. So through that process, you begin to ferret out when the price discussions. It's not so much that the hospital selling is saying, here's how much we want. Oftentimes you'll wait to get the expressions of interest and or the responses to the request for proposal back in, and those will already have a price in them. For-profit buyers are much more aggressive in this regard, and they will give you a price, and oftentimes they will be very, very definitive about how it's priced, what the net working capital needs to be, whether or not receivables are going to be part of the deal, whether or not certain assets are going to be part of the deal. And what we oftentimes see is on the not-for-profit side, they tend to, not all of them, but many of them tend to be a little more vague about the deal structure, a little more vague about whether or not they're willing to pay for something. And in many cases, you don't see not-for-profits paying to buy other not-for-profits unless they're small organizations and it's easy to do.
Adria, it's Trey here. Can I add something?
Please.
So I think everything Roger said is correct. You'd love to be in a situation where you're working with your hospital where you send out, as Roger described it, a book or a confidential information memorandum we might write, and you solicit both price and non-price terms from potential partners or buyers via an expression of interest that they would return to you. And you hope that you get in a situation where you can, as Roger said, whittle down that group to find who the right partner is going to be. Couple points I want to make there. First of all, what happens if you don't have multiple parties to whittle down from? And it's a tough situation. It only takes one, but in a process where you go out and approach a lot of groups, you hope you have more than one or many more than one to compare your offers against each other. And again, it's not just the price piece of this, it's the non-price piece. I talked about some of this at the beginning of my remarks, but what about making sure that all of your employees are hired at their current rates of pay and seniority? What about making sure that your partner organization has agreed to keep all of your current services in place for a minimum of 3 to 5 years after a deal closes? What about adherence to ethical and religious directives of the Catholic Church? And so you start to think about all of these other issues. Price is important, but it's not the most important thing many times to not-for-profits. They want to be sure that the fit is right first. And that's when the reverse due diligence comes in to really explore whether groups, be them for-profit or not-for-profit, fit along with the existing hospital and its service to the community for the past 100 years or so, as we've talked about before.
Yeah, Rich Reiner, I would add that a lot of times in a merger, of course, price isn't a major consideration. One of the considerations, of course, is assumption of debt for the transfer of the assets. If there's not a foundation in place, sometimes we'll make a donation to a foundation. And then one of the other key considerations is what will you commit from a capital perspective. So many times we have an internal capital model that our corporation has, but in a merger situation, we might ring fence a facility by itself, and if we can improve operating performance through reduction use of corporate services, better pricing on contracts, what we'll say is we'll spend X percent of the EBITDA, which is a term that most of the industry uses to allocate capital off of. We'll make a commitment of amount of capital for about a 5-year period of time for the institution that's being acquired to give comfort level that we'll do what we say we'll do. The other thing that we have found has been very helpful is that all the things we say we'll do, if you merge away the fiduciary board, there's really nobody to hold the acquirer responsible or accountable. So typically that's we transfer that, what we call enforcement rights or obligations that we agree to the foundation, who has legal right, and we give that in the documents to make us perform for what we said we'd perform in the affiliation documents. And that's a model that has really worked well for us. One, we put some money in a foundation, and two, we give that foundation, who is a self-perpetuating community foundation, the rights to enforce against us what we said we would do.
Thank you. And let me follow up on that, Rich. If I were, one thing that I see often in my practice is the lawyers get involved when the price has been negotiated and a lot of the substantive deal terms worked out and put into a signed letter of intent. And you know, from our perspective, there might have been some value added if we'd been involved earlier in the process. But I'm curious if from the perspective of a hospital that might not have the experience or the resources or have more limited experience and resources, at what point would you, do you think they should start bringing in advisors, lawyers, consultants? I've heard that come up occasionally in connection with particular subject matter expertise. But do you have any thoughts on how and when one should start working with particular consultants and experts?
Very, very early. It's actually better if somebody like us is going to acquire a standalone single community hospital. Actually works better if they have good counsel and had good counsel very, very early on, either general counsel or somebody, general counsel that gets expertise in mergers and acquisitions. And the second piece, as I said before, helpful to have a business consultant who helps give comfort to the community board that this is a fair and reasonable transaction and can help answer questions for the community board through the process. So, you know, we've done some transactions where early on the small hospital didn't have a consultant, and we basically said, here, we'd like you to get a consultant. Here's a list to pick from. Please get one, because it makes our life actually easier if they have good counsel and a good consultant early on. It just goes smoother. Does that answer? I think that.
Yeah, no, that's great. Thank you.
Hey, Adrian, it's Roger. I would echo that as a deal lawyer, and I work on lots of transactions. It is so much easier as a deal lawyer to work with sophisticated counsel on the other side, because you end up, when you do that, you're working with people that understand there are things to argue about and there are things not to argue about. They begin to understand. They know what the market terms are, and you don't end up spinning your wheels and wasting a lot of time over things that just don't, that your client, the acquirer, or even the seller isn't going to budge on. And so I highly recommend that it is worth the extra money that a hospital may spend, whether it be to hire a good FA, a good investment banker, a good lawyer. It's really worth it because the transactions just go so much smoother.
Okay, thank you. And I'd like to ask each of you, actually, before I ask the question, let me, for our New York and New Jersey folks, if you'd pick up your pen again, I'm going to give the second code, and that is Y as in yellow, the letter Q, E as in easy, Z as in zebra, and F as in free, YQEZF, for New York and New Jersey CLE credit. So I'd like to ask each of you, kind of coming into the last 10 minutes here, if I am with a hospital and I am planning for the future and kind of thinking that a strategic affiliation or being acquired might be one of the better options that's available to me as I position myself going forward, but there's not yet something on the horizon, so we're not yet negotiating the deal terms. What would be, given limited resources, limited employee time, and the like, what would be kind of one or two priority areas that I might want to think about focusing on to really just start building that foundation for a good transaction? Trey, do you want to start this?
Sure. You know, I think the answer may be dependent on how well they're doing financially. I'm going to assume that I'll answer it from both perspectives. One, a group that's doing reasonably well, and one that isn't. Let's say that you're a community hospital, a couple hundred beds, in a busy market competing against other well-heeled competitors, and you see on the horizon that you're losing a point of market share a year. You're starting to think about whether or not an affiliation or merger or sale or partnership is something that you should consider. And what I would be doing is building the case for either independence or not at that point, and trying to get in front of what might end up being a negative financial condition of your hospital early, making the decision early that in 5 years let's say in 5 years we're going to need a partner. What do we need to do now to get in front of that while our financial condition is still good and our value is the highest, quite frankly. So your ability to negotiate terms and conditions with a partner are better now than they will be in the future if you're in that situation. So starting those conversations with your advisors and potential parties in the market now will benefit you more from a price and non-price perspective than in the future. Let's say you're already in some financial distress and you know that you're going to have to do something relatively quickly. The first thing I would do is to go back to what I said in my remarks earlier, is to make sure that my revenue cycle management is up to snuff. Specifically, that there's no old bills lying around, and we've got policies and procedures in place to get bills out on time. Because if bills get too stale, I think everybody knows that you wouldn't be able to collect on some of that. So that's just money lying around that needs to be wrapped up. And related to that, to make sure that the net patient revenue is equal to your net cash collections, because cash is your most important thing at the end of the day, is to make sure that your positive cash flow continues so that you can continue to pay your bills.
Adria, this is Rich. I'd add one quick thing. As we have asked ourselves in markets where we're outside of Florida, are we relevant to the community and to payers? Will we be relevant? And if the answer to that is questionable or no, then we try to seek a partner who will give us that relevance. And partnership can be anything from a strategic alignment for, clinical integration to a joint venture to a full merger. So can you be relevant, and can you be ignored or not ignored by the marketplace long term?
Okay, and Roger, maybe kind of linking those two thoughts. How does the transaction structure, what sort of transaction models might we look at, or how might the transaction structures be driven by some of the due diligence or the good housekeeping that has been done up front by the target organization?
Well, a lot of times what we're seeing with transaction structures, Adria, is that sometimes if you want to leave, for example, I think about things like bond financing. Sometimes what we want to do is we want to leave bond financing. You've got two organizations with two separate obligated groups, and there isn't an interest, at least early on, to refinance the debt of either side. You want to be flexible, and you want to do that later. What we're seeing is, for example, a lot of kind of super parent structures where you'll take two organizations, you'll either put a new parent over the top of those two organizations, or the parent of one of the organizations will become the parent of the second organization. And you're able to, in that case, leave the bond financing in place. It also helps protect sometimes some of the liabilities of one side over the other. And so we think about that. The other thing we think about is accounting, merger accounting versus acquisition accounting. And I'm sure Trey and Rich spend a lot of time thinking about this, that you sometimes will, depending upon the weakness, the financial weakness of one of the parties, if there is financial weakness, and you're concerned about write-downs of assets, you might want to consider structuring your transaction so that you get merger accounting versus acquisition accounting, which helps avoid write-downs. So, your transaction structures can definitely implicate both your bond financing as well as your accounting treatment of the transaction, both of which can have either negative or positive effects on the deal.
Thank you. Trey, do you have any thoughts on that as well?
When it comes to an acquisition of assets versus a merger, we look at the value of those assets relative to the price being paid, and we start to get into some detailed conversations with our acquirers about the structure and should we do a stock purchase versus an asset purchase. And when we take a look at the balance sheet relative to those levels, that's when we get into those discussions. So I'd say this is probably conversation 2.0 for this audience.
Thank you. And we've taken some questions online, and I've asked a lot of questions. If there's anybody that's on the phone that wants to ask any live questions, you can open up the lines.
Thank you. If you would like to ask a question, please signal by pressing *1 on your telephone keypad. If you are using a speakerphone, please make sure your mute function is turned off to allow your signal to reach our equipment. A voice prompter on the phone line will indicate when your line is open. Please state your name before posing your question. Again, press *1 to ask a question, and we'll pause for just a moment to allow everyone an opportunity to signal for questions. And we will take our first question. Questioner, your line is open.
Yes, my name is William Barnes. I have a question about the due diligence. From your experience, how much is the due diligence cost on average as a percentage of the total value of the deal?
I'll take a stab. This is Rich Reiner.
Yep.
A lot of the due diligence, if we're acquiring something, is done with internal staff. We will engage outside counsel and or valuation people to value the transaction, and there may be some additional help from CPAs or accounting firms. But boy, I don't have a good number in terms of what the price of all of that due diligence is in light of a total transaction. I don't know.
Yeah, it's Trey here. I can take a stab at that as well. It depends on the size of the deal in part as well. The absolute dollars go up as the deal value goes up, but the percentages of the total deal value tend to decrease the bigger the deal gets. So, your investment banker could charge you 1% or 2% of the deal value. Your law firm, depending on how complicated the transaction is, could come in around the same number, although their pricing methodologies aren't usually on 1% of the deal. It's based on hourly rates and how many people are working on the deal and how complex it is. So, I would say it's a small percentage of the total deal value, most likely for a reasonable sized transaction. If it's very small, then the percentage would be higher, but the absolute dollars would be lower. So it's kind of a non-answer to the question. I'm happy to address that offline if you want to dig into some detail there too.
Oh, thank you very much.
And Adrian, it's Roger. One last thing to note is what we're seeing in a lot of deals is phased-in diligence. And the amount of diligence that you're going to do will depend upon several things. It'll depend upon deal structure. It'll also depend upon whether or not I'm working on a very large deal right now where the attitude was, we want big picture problems, and that's it. because we're going to do this deal come, hell or high water, we're going to do this deal. So the way we've done a lot of deals is we phased it in. We'll do phase 1 diligence, which is what's the kind of diligence we need to get us to a letter of intent. And then phase 2 might be what's the kind of diligence we need to do to get us to a definitive purchase agreement. And then depending upon whether or not the definitive agreement has any outs in it, diligence outs in it, what's the third level of diligence we need to do? So you can kind of phase it in and absorb costs that way on a phased basis.
Thank you very much.
Thank you, Roger. Thank you all. And I know we're up at 1:30. I don't, operator, are there any other live questions that we should take before we wrap up?
There are no additional questions at this time.
Okay, well, I'd like to thank all of the speakers and everybody that called in. I know it was educational for me as well. And please, as I mentioned earlier, we're going to have some in-person meetings coming up in the fall, and our next Access to Capital series will be in May. So stay tuned and watch for that. And thank you, everybody, for joining us. Have a good afternoon. Bye-bye.
That does conclude today's conference. Thank you for your participation.